Welcome back to the second segment of this law session on human rights. Now, where we were just before the break was looking at the Human Rights Act. And I want to follow in the same vein and continue on by saying that before the Human Rights Act, the convention could only be enforced in the European Court of Human Rights in Strasbourg. Now, if you're doing an abbreviation of the European Court of Human Rights, it is written as uppercase EC, lowercase t, HR. And if you're writing the ECHR, so the European Convention on Human Rights, that's ECHR. So please make the distinction if you're abbreviating, and they are accepted abbreviations, for example, in your writing. So ECHR for the convention, ECTHR for the court. So it was enforced in Strasbourg, but it was not enforced in the domestic courts. Now, citizens in the UK who wanted to claim that their rights had been breached had to, of course, make their application and certainly go to Strasbourg in order to substantiate a claim in respect of those rights. Now, this was a little bit ironic because the UK actually played a leading role in the drafting of the European Convention of Human Rights after the Second World War, and indeed they were one of the first to actually ratify it, meaning to approve and endorse it. Now, the European Convention on Human Rights was indeed a convention aimed at preventing a recurrence of the kind of atrocities that were seen before and during World War II by ensuring that all European states signed a declaration to abide by the common standards of human rights. Now, I want to pause and say this, that the vast majority of constitutions will indeed, most of the newer constitutions, so most of the countries who will have obtained their independence from Britain will generally have, in respect of rights of the citizens, a somewhat similar framework or statements as are set out in the European Convention on Human Rights. So when you look at your own constitution, if you're in a country outside the UK, look at the constitution and you will see that it does mirror, for the most part, articles of the European Convention on Human Rights. So the idea was that there should be a common standard of human rights. Now, this was intended to guarantee the citizens of Europe some basic rights and freedoms. Now, when we look at the European Convention of Human Rights articles, the ones that were actually brought over into UK law, they are not all of them, by the way, and that will be important later on. So, for example, Article 1, which guarantees all rights, was not brought over. Now, when we look at the European Convention on Human Rights, the articles which were brought over, of course, were Article 2, which is the right to life, Article 3, freedom from torture, inhumane or degrading treatment or punishment, Article 4, freedom from slavery or servitude or indeed slave labor, Article 5, which looks at freedom from arbitrary detention, Article 6, right to a fair trial. We will go through a somewhat in-depth look at Article 6 because Article 6 is very important, and I will flag up for the first time, but not for the last, do not confuse your Article 6 of the European Convention on Human Rights with your Section 6 of the HRA. Examiners know that law students tend to make this error and like to set questions on Section 6 of the HRA, and students tend to pick this up and run with it as Article 6. So Article 6 looks at the right to a fair trial. Article 7 looks at the prohibition on retrospective legislation. Article 8 looks at the right to respect for family life. Article 9 says you ought to be free in your thoughts, your conscience, and your religion. And Article 10 looks at the freedom of expression. Article 11, of course, gives the freedom of association and assembly. Article 12, the right to marry and found a family. And Article 14, the right to the enjoyment of rights without discrimination. Now, there are the protocols to the European Convention on Human Rights, and Article 1, which is the right to peaceful enjoyment of one's possessions. Now, this is an important one, certainly for any law student doing land law as well, because it was the Article 1 right which was being pleaded in the case of the adverse possession case of PI and the UK. So Article 1, Protocol 1 looks at peaceful enjoyment of your possessions. Article 2 of Protocol 1 looks at the right to education. And Article 3 of Protocol 1 looks at the right to free and secret elections at reasonable intervals. Now, when you look at the European Conventions on Human Rights overall, it consists of 18 articles, 6 protocols, and it of course has certain additional rights which have been added. As I mentioned before, not all of these are brought into UK law by virtue of the HRA. Now, one significant omission is Article 1 and Article 13. Now, precisely because Article 13 was being kept out means that Article 1 had to have been kept out because Article 1 guarantees all of the rights under the Convention. Now, Article 13 guarantees the right to an effective remedy before a national authority. When you look at Article 13, this has been kept out in the articles which have been brought over. What the UK has done instead is to enact Section 8 of the HRA, which provides for a discretionary remedy. Now, you will see that this is different from an effective remedy, because an effective remedy will generally mean a remedy which more or less fits whatever the matter is before the court. A discretionary remedy means that the judge can take into account certain types of considerations, for example, public policy issues, in considering whether or not to grant a remedy. Now, the ECHR's impact prior to the HRA was such that if a person's civil liberties had been breached, then the convention did offer the possibility of a remedy in the absence of any recourse in the domestic courts. Now, the action, as I say, had to be brought before the European Court of Human Rights, because the fact was that if you did not have something or something in place in your local court, then if your country is a signatory to the convention, then because there was this court framework, you could of course bring the action before that court. I do also want to pause and say this: do not confuse the European Court of Human Rights with the Court of Justice of the EU. They're two completely different things. The CJEU, or the ECJ as it was called before, has to do with the 27 member states who have signed up to the European Union. When you look at the European Convention on Human Rights and the European Court of Human Rights, it is that framework to do with the Council of Europe and this whole idea of guaranteeing rights. Now, when you look at for example, the governments or the various signatories to the convention, governments were allowed to make some derogations under the convention, meaning they could depart from articles of the convention under very special circumstances. Now, if we look at the HRA of 1998, which actually came into force in October 2000, as I said, it did bring over the main provisions of the European Convention on Human Rights into domestic law in the UK. Now, Section 1, and we're going to look at some of the sections now. Section 1 in the HRA, in the Act itself, speaks of convention rights. And what it means are the rights and fundamental freedoms which are set out. And it tells you which ones are being brought over. So Section 1 of the HRA tells you in Section 1A that Articles 2 to 12 and 14 of the Convention, and Articles 1 to 3 of the First Protocol, and Articles 1 and 2 of the Sixth Protocol, as read with Articles 16 to 18 of the Convention. Now, this new legislation, this new HRA, enables citizens to use the incorporated articles of the ECHR in proceedings in the UK courts, rather than taking their case directly to the European Court of Human Rights in Strasbourg for a remedy. Now, when we look again at the HRA under Section 2, the HRA requires the UK judges to take account of decisions of the European Court of Human Rights. So the jurisprudence which had come out of the ECTHR can be relied on. Section 3 says judges, when they're interpreting legislation, as far as it is possible to do so, they should interpret it in a way which is compatible with the convention. However, if it is not possible to interpret an act of parliament so far as it is to make it compatible with the convention, the judges are not allowed to override it. Remember, when we looked at parliamentary sovereignty, I did raise the point about Section 3. Section 3 seems to want to be some kind of soft form entrenchment by saying that all acts should really be read in light of the HRA. So if there was an act of parliament, for example, let's say there's a fictitious act of parliament that says that you can be tortured in a situation where the government needs to get emergency information. Well, that of course would go against the articles of the ECHR that says that you ought not to be tortured. The point, of course, being that such inconsistent legislation ought to be, by virtue of Section 3, be read in light of the HRA. The point, though, is that a court cannot use Section 3 to make an act of parliament invalid. What they can do is set out under Section 4, which is to make a declaration of incompatibility. Now, what we see with the HRA is that it does try to keep the constitutional principle of parliamentary supremacy intact. Now, a very important section of the HRA is Section 6. Section 6 of the HRA deals with acts of public bodies or public authority. Now, it is unlawful for a public authority to act in a way which is incompatible with convention rights. The point for you to bear in mind is that under Section 6, subsection 3 of the Act, public authority does include a court. Now, this is important because when you look, for example, at issues relating to judicial review, in particular, when you're looking at a decision being made by a court, then it must be borne in mind that you can judicially review the acts of a court based on the fact that a court is considered a public authority. Now, again, I will remind you, be careful not to confuse the HRA Section 6 with the ECHR Article 6. They are and remain two different pieces of legislation insofar as what they provide for, and so you should ensure that you do not confuse the two. Now, as it relates to Section 6, as I said, deals with acts of public bodies. Article 6 looks at the right to a fair trial. Now, when you look at Section 6, the Act makes it unlawful, as I say, for any public authority to act contrary to the rights that are set out in the Act. There are some cases that would be interesting for you to look at, not least Wilson and First County and Venables and Thompson News Group newspapers. Now, Venable and Thompson's is about the Jamie Bulger case, and in that case, it was the idea was that these two young boys who had killed an even younger boy did so when they were about 10 years old, and the idea was that they were imprisoned, and then later on, as they got older, they were now being given new identities because it was a really awful crime at the time. Now, newspapers were seeking to print their identities as they were now, and an injunction was granted to stop the newspaper from publishing the information about these child murderers. Now, the court held that the ECHR applied even though this dispute was between private parties, the newspaper and these individuals. And it is interesting to, of course, see that it does have the kind of, to borrow a phrase from the EU framework, it does have the kind of horizontal effect, meaning as against individuals. Now, when you look at Douglas and Hello, and this was to do with Michael Douglas and bringing an action against Hello magazine, one of the things that has been argued is about whether these celebrities have any kind of privacy. And we see privacy laws making an inroad in UK law and trying to garner some kind of band of case law. The point to remember is a right to privacy does not exist under the convention. Now, when you look at the sections of the HRA, again, there are certain important sections for you to bear in mind. We have looked at, for example, Section 2, which looks at the interpretative powers, and we've looked at Section 3, the sub-form entrenchment, certainly Section 6, and also when you look at Section 8. Now, I will, of course, want to carry on in more depth on this, and what I want us to do is take a short break again so that you can digest some of this, and immediately after the break we will continue looking at the HRA.